Hello.
Welcome, everyone. How goes it? Welcome to another episode of the Justice Revolution. I am your host, James the Patriot. So my co-hosts are not here.
I'm
not
here.
sure what happened to Justice. Erica said she's going to join us in a little bit, but I have my fill-in host, Crash, the constitutional peasant. I love that, by the way. Crash, welcome.
Hello.
It's been a while since we've had you on. We got to have you on more frequently because I love the fire you bring to our show. So, and guys, we have with us today our guest for today, Captain Cross.
If you want to call it that, yeah, sure.
Yeah, Captain, welcome. How are you?
Good, very, very well. Thank you very much for asking. How are you, James? We haven't talked in a while, so here we go.
Yeah, it's been a little while. We've got some really good updates for you. You guys, if you remember, we had the captain on, I want to say 2 or 3 months ago, maybe not quite that long ago, talking about his lawsuit against American Airlines, correct?
Yes.
Okay. And it was surrounding the mandatory jabs. Okay. So that's what we're going to talk about with him. But before we get to the captain, I have a few things I'd like to share with you all. Some updates on a few things. If you remember from our show from last week, I was talking about how I had filed my property tax lawsuit and I was waiting for an answer. And I had told everybody that I had spoken to the attorneys. They said that they planned on filing a motion to dismiss. Well, they did file the motion to dismiss at about 15 minutes to 5 o'clock in the afternoon. Not surprising. So, Erica, hello, welcome. There she is.
Hey, guys.
So,
hi, Erica.
She's going to have to, did you already take your son to school or are you going to have to step away?
No, I am going to have to step away. We just got so involved. We were studying the Bill of Rights from the Indiana Constitution. So it just carried us away.
How dare you talk about the Bill of Rights? That's just, I mean, we the people. Do you see the banner behind my head? We the people. I mean, hello. That's what this is.
Specifically for those accused of crimes and stuff like that, the rights that they have. Right. I spent yesterday getting this whole file together on. It's called the Erica Got Busted file. I don't know, just in case I get arrested for something, or I've got an affidavit of kidnapping in there. I've got my non-statutory abatement. I've got my motion to dismiss based on lack of subject matter jurisdiction. So it's just all ready to go.
Good.
So
well, just
relax.
I realize it's better to be prepared than not prepared, but let's just hope it doesn't come to that you ever have to use that. So
right, better to have it and not need it than need it and not have it.
Good saying. Good. Well, we're glad you're here. Justice hopefully will jump on here sometime soon. I haven't heard from her yet this morning, but I was just giving everybody an update on my property tax suit. So because when we did the show last week, they hadn't filed a response. They hadn't filed a motion to dismiss, but they did. At about 15 minutes to 5 o'clock, they filed a motion to dismiss. Their basis for that motion to dismiss is two things. So under Rule 12 of the Federal Rules of Civil Procedure, there's 7 things that you can file a motion for, a pre-answer motion. The first one is for lack of subject matter jurisdiction, which they cited. And then the most common is number 6 for failure to state a claim. So I took a look at the motion on Friday, and I sent a strongly worded email to these attorneys because clearly, well, one of two things happened after they read my complaint. Either they don't understand and comprehend plain English, or they are deliberately, which I feel like is the case here, they're deliberately attempting to influence the court in a different direction. So I'm going to talk about that here in just a second. I want to show you guys what the ridiculousness of their motion, and Captain Cross, I'm sure, can attest to this with the cases that he's been litigating. We'll get to that here in just a few minutes. But first, before I do that, I want to address something that's really been bothering me. Last week on our show, we had a number of really good people adding comments to our chat. So, and I really appreciate everyone that contributes to our live streams. There was there was an individual who I asked to IM me, and this individual did so because when they were talking on the show, I was like, oh, this sounds like it's a concerning problem. So this individual IM me and gave me the information, well, bits and pieces of it, I should say. I didn't get the full picture. I did the best I could to help this individual and to direct the individual which way to go. But it was clear to me that this individual was wanting me to do it all for him or her. And I've said this before, you guys, I would love nothing more than to just do this for anyone who asks for help. The rules prohibit that, number one. And number two, I am not physically capable to do this for everybody who reaches out for help for me. If we are to restore this republic to the once great nation that it was, when you could walk up to anyone on the street and ask them what the Seventh Amendment protects and they could tell you, we need to take ownership of our own problems, and we need to learn how to litigate our own issues. It doesn't mean I'm not willing to help read something that you've written up. It doesn't mean I'm not willing to give you constructive criticism, because I am. But I will not, under any circumstances, be belittled because you don't think I'm doing what you want me to do. Hey, Justice. So I'm standing on my soapbox right now. And if I'm coming across harsh, I am sorry. That's not my intent, because I'm trying to help anybody I can. I have never, in the almost 3 years I've been doing this, taken a dime from anyone, nor will I ever. So don't sit there and point your self-righteous finger at me and claim that I'm not doing what I should be doing to help you. Your problems are just that, your problems. Own up to it. If you don't like what I'm telling you, that's your problem, not mine. Okay, stepping off my soapbox.
I'm going to piggyback your soapbox real quick, because I touched on this on Monday. And, our entire nation has become very complete. Like, I have a degree in aviation and everything, so I'm supposed to be a pilot. And that's all people say, you're a pilot. That's what your specialty is. Well, no, I've actually been studying herbal medicine for 15 years, and I have other things that I'm interested in, and I study as a hobby. So I know a lot of things, and I fix things. And if I need to know how to do something, I learn how to do it.
Yeah.
And I think that it's a new phenomenon as of the last 75 years that people are specialized and feel like they're experts in one thing and they can't learn other things. But we used to have to always fix our own farm equipment and trucks, and there wasn't an expert to show up to do the plumbing or whatever. You fixed it. And I think that that applies to legal knowledge and holding our own ground as a country more so than plumbing. And I think people just have inherently become complacent and dependent on the legal system and people that they see as more, when in all reality, we all need to not just have a basic understanding, but we need to understand it inherently so that we can apply it and protect our kids.
So true.
All right, I'm off my soapbox.
Thanks,
by
Craig.
design to make us lazy as well. And
Yeah.
as I mentioned to James, there's also trolls out there designed to take people down that are doing good and are over the target. So
distractions.
Yeah. No, and that's absolutely the truth. I mean, I'll give you a good example here and then we'll move on. So we've had on the show, Adrian has been on the show with us before. You guys remember her. She's dealing with a frivolous lawsuit for a debt collection. So I brought her on to show you guys what to expect when you're being sued by these sleazeball liars who purchase this debt for pennies on the dollar and then try to enforce this through their justice system. She's taken the bull by the horns. She's taken the how to win in court course. She's written up her own draft of documents. She's put them in the chat. People have given her constructive criticism. She does this stuff and then asks me, hey, will you review this and make sure there's nothing I'm missing? Or can you help me find some case law around this? I am ready, willing, and able to do that all day, every day. I love nothing more than reading lawsuits when I have the time to do it. There was recently posted in one of the groups that I'm in the Law Society, which is Randy's group. a gentleman in Seattle. I believe his screen name is Seraph de Montego or something like that. He posted this lawsuit that he just wrote up. It's 280 pages.
Woo.
But it has to be that long. I mean, when you see all of the list of everything that he's got in there, it's insane. But the dude is sharp as a tack. I was just reading through the first few pages, his introduction. This guy's going places. This is what we need. We need more people like that. So, again, I apologize for using this as my soapbox moment. I was really hurt and bothered by the comments that this individual posted directed at me. Well, you haven't won anything and you haven't done anything. Is like, that means zero zilch. Guess what? I've had little victories that have gotten me what I wanted. I sent a strongly worded document to my daughter's principal and I got her out of state mandated testing. I count that as a win. It's the little things. It's the little things that we do that justify these things moving forward. Now, with that being said, let me talk real quick about my lawsuit, and then we'll bring Captain Cross on, and he can fill us in on his. So let me pull up this. All right. So when we did the show last week, whoops, that's mine. That's not the one I want. Sorry. When we did the show last week, I was still waiting for the defendants in my case to oh yeah, that is the one I want. Was the defendants in my case to file a motion, and they hadn't done that just yet. Now they did finally by the end of the day file this motion, and it's right here. So they're moving to have my case dismissed under these two rules: Rule 12b-1, which is for lack of subject matter jurisdiction, and or alternatively Rule 12b-6. This is interesting why they used or alternatively, and I'll talk about that here in a second. I'm sure Captain Cross can verify this. Okay, so the basis of Rule 12b-1 is lack of subject matter jurisdiction. Okay, here's what I find is fascinating. Under the facts section of their motion, which by the way are all unsupported because this is just signed by the liar. Under the facts section of this motion, it states right here, defendants each in his or its own role assessed an ad valorem property tax against plaintiff's property in Weber County, placed it on the tax roll, notified plaintiff of the taxes owed, and attempted to collect the taxes owed. Do you guys know why that statement is significant?
No.
Captain Cross, let me ask you, if I stated unequivocally in my complaint and that there was no evidence attached to that I am not a taxpayer, why is this that I just read relevant?
I'm going to have to claim ignorance on that.
I think he's probably trying he's addressing you as a living man and then you as the entity of a taxpayer.
Bingo.
Right?
There you go. Yeah. I actually reached out. I sent an email and I reached out by phone. So this would have been Tuesday earlier this week because Monday was Labor Day. I talked to them on Tuesday and I said, hey, gentlemen, I'm not sure. I said, I got your motion to dismiss. I gotta be honest. I'm very confused. From what I'm reading, I said, is your assertion that I am a taxpayer? And they said, yes. Okay. So you feel that I'm a taxpayer. All right, great. Nowhere in my complaint did I state that I was a taxpayer, nor is there any evidence that proves I'm a taxpayer. Okay? That is the key. Just because you make the statement that I'm not a taxpayer, well, that's a legal conclusion. But you'll see, or I'm not going to pull it up, but numerous times in my complaint, I stated I am not a taxpayer, nor am I in receipt of any documentation that would act as strict evidence of that fact. Is that something that anybody can rebut? Well, sure. They can bring the evidence.
Right, yeah.
So
but there
who's
is
the burden on now? The burden of proof is on who to prove that I'm a taxpayer?
Yeah, it's on them.
It's on the other side. So this This is why I'm saying, you guys. I mean, it never ceases to amaze me what these liars do in their court documents. He just put on paper and admitted that his defendants, or excuse me, that his clients assessed an ad valorem property tax against a non-taxpayer. That's the nail in the coffin right there.
Yeah. Does the word "it's" is that what's describing you as a taxpayer, as an
no, because I
that's
named
talking about the defendants. Okay,
Yes,
so you're
yes,
talking
Yeah, those are the
about the
defendants.
corporations and the individuals.
correct. So
Okay.
I named 5 defendants. I named 2 individuals who are elected to those positions. So it was the county assessor and the county treasurer, and then I named the county assessor's office, the county treasurer's office, and then the county itself,
Okay.
because those are legal entities and they can sue or be sued, right?
Right.
So
I
that's
was
what he's talking
thinking.
about here.
I was thinking
Okay.
for some reason they were saying you, and it. Never mind. But yeah,
Yeah.
still
No.
the same principle.
Same principle. Yeah. So basically, just to save a lot of time, this entire motion, which is 11 pages, it's not very long. The entire thing rests on the fact that I'm a taxpayer. Now, if I went in there and I didn't dispute the fact that I'm not a taxpayer, then he would absolutely have a leg to stand on, but he doesn't, because of the fact that he does nothing to bring any kind of evidence forward. So let me just show you right here. He says the court does not have subject matter jurisdiction, so the case must be dismissed. According to this federal statute, 28 USC 1341, it says that district courts shall not enjoin, suspend, or restrain the assessment, levy, or collection of any tax under state law, where a plain, speedy, and efficient remedy may be had in the courts of such state. Okay, so what is the plain, speedy, or efficient remedy? Well, if you're a taxpayer and you don't agree with a tax that's being assessed, you can challenge that in a state court. And this law right here says that if you are a taxpayer and you don't agree with the tax that's being assessed, that you cannot challenge it in a federal court. That would deprive the federal court of subject matter jurisdiction, which is the entire argument this guy's making. Okay? Here's what's interesting too. He says under Utah's property tax code, it establishes the method for challenging such a tax. So when you see person listed in any of these things, that's referring to the legal entity, to the taxpayer. A taxpayer is a person. And then he goes on, plaintiffs does not mention, let alone address this statute. Well, duh, numb nuts, because I'm not a freaking taxpayer. I mean, this is why I was like, you guys, my head spins sometimes. I was like, do you understand plain written English? Or do you just choose, oh, there's no way that you can't be a taxpayer? Everybody's a taxpayer. You have to be a taxpayer. Says who? Again, these guys, these supposed learned guys who went to law school, who have a degree, who have a bar card, they don't even know their own rights.
Yeah.
And it's sad. It's just sad. Here's what's interesting. It says the statutory process to recover property taxes in Utah is essentially the same as claiming refunds from the IRS. And here's what it says. The Internal Revenue Code provides methods to ensure due process to what?
Taxpayers.
Bingo. Okay. That's his first one. His second one, and I'm going to scroll down, says the plaintiff's complaint fails to state a claim upon which relief can be granted. Again, if I'm a taxpayer, he would be correct. But I am not. And I'm just, because this is ridiculous, I'm just going to go through this. He even cites the Utah Constitution establishes a property tax. Correct. So that each legal entity, person, and corporation pays tax in proportion to the fair market value of his, her, or its tangible property. Again, two different things. Just because I was born on this ground and just because I buy a piece of property within the territorial jurisdiction of your county does not grant you rights in my property. That is about as asinine as me sending a tax bill to Crash in Mississippi.
But they're saying though that you are liable because you registered on their rolls.
No, I didn't.
Right?
I didn't
Is that what
register.
they're
On, no,
saying at the
I didn't do anything.
They did it.
Your title company did it?
No, I went back and I reviewed my closing documentation. Guess what? I did not sign anything that granted anyone the authority to tax me. Review your closing documents. So it's everyone is different. It doesn't matter. And even if you do sign something, it still doesn't grant them rights in your property. Why, Erica? Why doesn't it grant them rights in your property?
You can't tax private property?
You cannot tax private property because you have an unalienable right to acquire, possess, and protect property, and rights cannot be taxed.
The property tax issue goes far beyond that. There's an issue going on in my county right now with some people I know, and that they paid off their land. And when they paid off their land, she said that it says that it's not that they own their land. They are now leasing it from the tax office. I forgot the exact term that she used, but it's not a deed of ownership. It's a deed of lease to the tax office.
Yeah. And again, you guys, this is if you look and Crash, I'll tell you right now, if you jump onto your county's website and you look at the process for collecting unpaid taxes, like if they do a tax sale, you're going to see the county guarantees no right of possession of this property. Buyer beware. That's exactly what it says. So they are selling property that they have absolutely no rights or authority to sell.
Yeah.
Zip, zero, zilch. So, again, this guy's entire argument here goes on about how I don't make any argument how the property tax is unconstitutional. He's right. I don't make an argument that the property tax is unconstitutional because it's not. It's a constitutional tax when it is assessed to a taxpayer. Their process for assessing this tax against me, a non-taxpayer, is unconstitutional. Okay, so let me get rid of that. And I'm going to show you my response real quick, and then we'll jump into Captain Cross. Okay, so here's my response. And then also, too, you guys need to understand something. When a defendant challenges the court's subject matter jurisdiction, if the court dismisses the complaint based on lack of subject matter jurisdiction, it does not dismiss the complaint with prejudice. You are welcome to change or fix those jurisdictional deficiencies and refile again, just so everybody knows. Under Rule 12b-6, that's where it gets a little dicey. It depends on the way that the ruling is done. But here's what I said. I'm asking the Honorable Court to deny their motion to dismiss, as this motion is frivolous and is, in plaintiff's view, a violation of Federal Rules 11b-1 and 3. So, Captain, do you know what that rule is?
You know, you're stumping me because I'm not so involved in that kind of. I'll say no. I have.
Is that the one where they're intentionally delaying?
Yes, it's so. Rule 11 of the Civil Rules of Procedure is presentation of papers before the court, and Rule 11b-1 and 3, which I'll read down here in a minute, specifically states that the paper is not presented to the court for an improper purpose, such as to intentionally delay the proceedings or increase the cost of the litigation, or for frivolous purposes, meaning the arguments presented have no basis in law or in fact.
We talked about that last week. Yeah.
Mhm.
Yes, in law or in fact. Okay. Now, here's something else that's always a good thing to do that Dr. Graves talks about in his course. The courts want people to resolve their issues if they can amicably. So I did that, and I put it in my motion here. Did you guys notice that in their motion they didn't specify that we had talked before they filed that? No.
Yeah.
But I did. Plaintiff's good faith effort conference. Plaintiff, after receiving notification of defendant's motion to dismiss, emailed the defendant's counsel to point out factual deficiencies and request the defendants withdraw the motion and file a proper answer to plaintiff's complaint.
Nice.
Additionally, at approximately 10:45 a.m. on September 5th, plaintiff conferred with Mr. Erickson and Mr. Crockett via phone again to discuss these deficiencies. After a brief discussion, the parties were unable to come to a mutually agreed upon resolution and now seek this honorable court's intervention. Okay? Hey, Judge,
Right.
I'm willing to work here. These guys are being unreasonable.
Mm-hmm.
Okay? Now, I'm going to read the introduction because I really feel like this is important information to get across. One of the things that Dr. Graves states is every time you have an opportunity to present a written motion or paper to the court is another chance to state your case. Okay? Remember that. Introduction. It is not now, nor has it ever been, plaintiff's intention to avoid paying a lawful tax to which he may lawfully owe. Real quick, too, Dr. Cross, how much time do you have? I don't want to take away time from you.
Oh no, I'm listening. I'm learning a lot from what you are.
Okay, I just want to make
saying
sure
because there are areas. These are some of the areas that I really did not get into.
Okay.
In my cases.
Okay, good. I just want to make sure that I don't want to hold you over too long.
No, by all means, go ahead.
So, okay, good. So, it is not now, nor has it ever been plaintiff's intention to avoid paying a lawful tax to which he may lawfully owe. However, when researching the revenue laws and state and federal constitutions, plaintiff was unable to find any adequate evidence in law that requires one of the sovereign people of the Union State of Utah to pay an ad valorem tax on their personal property that they have a right to acquire, possess, and protect. See Utah Constitution, Article 1, Section 1, simply because they own property within the territorial jurisdiction of a levying entity. Any qualms or problems with that statement?
Only that possess is spelled incorrectly, but I love where you're going with this because
Erica, just stop it.
Classes. I don't know.
I realize
You beat me to it.
Take your teacher hat off. I know that you've just been doing homeschool.
Sorry,
Just-
I can't do it.
Homeschool moms never take our hats off.
You're gonna find a number of typos in here, okay? I'm sorry. I was never good. Nobody learned me good or how to write better. Okay?
You sure you didn't
No,
go to
but
Louisiana school?
I think you clearly communicated though that you're not challenging anything that he mentioned in his motion to dismiss. You're not saying that it was an unconstitutional tax. You're not trying to get out of paying taxes. You're simply looking for the evidence that you are lawfully required to pay that. And that says it very clearly.
Yeah, exactly. So, defendant's counsel has asserted.
I think it's
within their
so
motion-
interesting that.
No, go ahead, Crash.
I think it's so interesting that lawyers are not actually backing this, because I know that they have a lot of property taxes that they pay on their huge houses and stuff, especially out in Utah. And I just don't understand how they would not be like, oh wow, this is great, we should jump behind this, because if the people stopped paying such ridiculous property taxes, they would have more money to contribute to the area, and sales tax in the area would more than make up the difference of whatever property taxes they're collecting.
Well, here's a common misconception that is portrayed on the people, Crash. There is more than enough money generated from sales tax revenue right now.
Yep.
To more than enough to fund the government and then some. So
Clearly, look at Ukraine.
what I'm saying is that if every American so what I'm saying is if every American stopped paying income tax and property taxes, there would be more than enough money to fund the government.
The Rothschilds would have to auction more.
Exactly. That is the big lie. Okay. So let me move on here. It says defendant's counsel has asserted within their motion to dismiss that this court lacks subject matter jurisdiction to hear this case, and that plaintiff has failed to state a plausible claim for relief. As in counsel's words, plaintiff has stated multiple legal conclusions and no factual allegations. Plaintiff is left scratching his head wondering what pleading counsel was reading, or if they read the pleading at all. The basis that this entire motion to dismiss rests on is one simple issue of material fact, according to counsel, and that is that plaintiff is a taxpayer. Now you'll notice I use the words issue of material fact. Do you guys know why I chose to use issue of material fact?
No.
Anybody know? Captain Cross, would you know why I would say that?
Oh. Well, because it has to be supported by law.
It does. But guess what I can do now, because this guy was dumb enough to state in his motion to dismiss that they assessed a tax on me and they did all this stuff. I can actually move for summary judgment, because one of the requisites of summary judgment is that there is no issue of material fact between the parties. They contend that I'm a taxpayer. I've contended that I am not. They admitted that they assessed a tax that's only accessible to a taxpayer against a non-taxpayer. That's why.
Okay.
I said, plaintiff finds defendant's motion to contain multiple false statements, meritless legal theories, excessively voluminous and unfocused ramblings that are so confusing, ambiguous, vague, and unintelligible to the point the plaintiff is left wondering if defendant's counsel can read and comprehend plain English. Thank you, Alphonse, for that one. Plaintiff finds this motion to dismiss frivolous for failure to state any legal deficiencies within the four corners of plaintiff's complaint. See, there's another typo. And therefore should be denied for the following reasons. Okay. I'm not going to go through this whole thing. It's posted in our group. You guys can read it. But again, I just reiterate about the undisputed facts. I said by defendants by and through their counsel have stipulated that the following facts in plaintiff's complaint are true. And I just go through and I list each one where they failed to provide any evidence of a licensed business activity, where they have each in their own or its own role assessed an ad valorem property tax. I basically copied this section right here, word for word, from their own motion to dismiss and put it in here. So again, thank you, counsel, for that one. Here is the big kicker right here. This is an undisputed fact. Plaintiff, as a non-taxpayer, has no adequate remedy at state law within the Utah Revenue Code, Title 59, to recover funds taken from him under the color of law. Rulings from the 10th Circuit Court of Appeals confirm as much. This is what they said. It is equally well settled that the revenue laws relate only to taxpayers. No procedure is prescribed for a non-taxpayer where the government seeks to levy on property belonging to him for the collection of another's tax. And no attempt has been made to annul the ordinary rights or remedies of a non-taxpayer in such cases. If the government sought to levy on the property of A for a tax liability owing by B, A could not and would not be required to pay the tax under protest and then institute an action to recover the amount so paid. His remedy would be to go into a court of competent jurisdiction and enjoin the government from proceeding against his property. What do you think I just did?
Yes, you did.
Yeah.
10th
Circuit Court of Appeals, 1948. Great case. Okay. Again, I don't want to go through all of this stuff here because, I've proven that I have subject matter jurisdiction, or excuse me, the court has subject matter jurisdiction because I'm a non-taxpayer. Okay. By the way, this is one thing here. I said, again, plaintiff is confused and left wondering where counsel got this assertion. Plaintiff stated numerous times and alleged numerous times that he was not a taxpayer and that the defendants have provided no evidence to him as such. See plaintiff's complaint at page 2, paragraph 2, page 3, paragraphs 2 through 3, page 7. I mean, I list it all out here. So you can't overlook this stuff. You can't. And you can't let these liars get away with this. This is why I affectionately call them liars, right? Because this is the crap they pull. I have stated a claim for relief under 12b-6 because where does it say right? Okay. I said the application of the state's revenue laws towards plaintiff and his private property are unconstitutional. Counsel would have this court believe that plaintiff contends that the property tax laws in and of themselves are unconstitutional, but nothing could be further from the truth. And that's the truth. I didn't state that the property tax laws were unconstitutional because they're not. I stated that their application of them towards me was unconstitutional. So I want to get down here to two things. Okay. Again, when a lawyer tries to insert things that are outside of the pleadings into the case and refuses to substantiate that with evidence that the rules require, what do? We call them out on it. That's what we do. So if you remember, I verified with the attorneys. I said, okay, I just want to make sure your assertion is correct. You are asserting that I am a taxpayer. Is that correct? And they said yes. Great. That is a material issue of fact that is outside the four corners of my complaint. So I'm going to make sure the court knows that. And it's right here. The entire premise of defendant's motion to dismiss rests on one issue of material fact that is outside the four corners of the complaint, and that is the plaintiff is a taxpayer. All of the defenses raised thus far rest on this issue of material fact that counsel has failed to substantiate with evidentiary support. At this point, it is merely a statement made by counsel, and it is well-settled law that statements of counsel in arguments or brief are not facts or evidence before the court. So if you'll notice, I'm citing the 10th Circuit courts. That's because that is my controlling appellate court. So how do we control judges? We make sure that we use case rulings from the controlling the controlling circuit courts. I then go on to say there is zero evidence within the record to corroborate counsel's theory that plaintiff is a taxpayer and subject to the state revenue codes as such. This is a gross error at best and a blatant lie at worst. The rule of law and the rules of civil procedure require that if this court wishes to use this information in consideration of a defendant's motion to dismiss, that this motion must be converted to a motion for summary judgment under Rule 12D, and that all parties must be given a reasonable opportunity to present all the material that is pertinent to the motion. Okay? You got to get that on the record. Because if this judge decides to grant their motion, I now have an appealable issue. Okay? And again, I point out the fact they failed to comply with the requirements of Rule 11B 1 and 3. This is what Rule 11B1 says. By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or an unrepresented party certifies that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, that the paper is not being presented for any proper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation, and that the factual contentions have evidentiary support, or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Okay, so if he wants to make the assertion that I'm a taxpayer, he would have to say, and I will be able to prove it after a reasonable opportunity for further investigation or discovery. He didn't do that. He didn't do that. He's basically throwing crap up against the wall and hoping it will stick. Okay? All right. Any questions on that, guys? Wow.
James, this is very I am way more polite or more reserved in addressing the court and my writings. I think I can ramp it up a little bit when I write, looking at what you wrote. So and I do need to dig deeper into the codes, because I'm strictly, for the most part, I'm strictly presenting arguments.
Yeah. Well,
which is just logical stuff.
Well, here's the thing. I would call it righteous indignation, right? I am standing up and asserting my rights, which you were doing the same. There's no difference in what I'm doing with what you're doing. We're just different issues.
Right.
Mine rests on property tax issues. Your rests on issues of the right to your own self-conscience. See, this is something that I want to make sure we get very clear when we're talking about your case, is that people think, oh, you have a right to practice your own religion. You do. And see, the government will have you believe that you have to be a member of some organized religion. That is not, I'm going to say it again, that is not what that right protects. That right protects your right to think for yourself, your right to make a decision for yourself, so long as that decision does not affect anyone else's rights. So
That's correct. That's correct.
So
Yeah.
if I choose not to do something to my body, how are you to tell me that by making that choice, it's going to affect someone else? That's what's called hearsay. You have no evidence. You have no proof of it. That's exactly what it is. So anyway, so that's where I'm at with my case. Guys, I didn't waste any time. I filed my reply on Tuesday of this week. So they now have 14 days to file a response. And then here's what else that I find is fascinating. Guess what the rules state that I get to do now? What do you think, Captain Cross? What do you think the rules state?
Tell me. I am just speechless this morning. Come on. Help me out.
Okay.
Pop quiz today, didn't you know?
James loves to put us on the spot.
I'm like,
all the time.
really, this is very, very informative. And
Great.
go on.
All right. So what I have on the screen here is Cornell Law School. This is one of my favorite places to go where I can find the rules of federal procedure. So here's Rule 12, defenses and objections, motion for judgment on the pleadings, waiving, and what's this one say right here, Captain Cross?
Pre-trial hearing you're going to do.
Pre-trial hearing.
Pre-trial hearing.
Okay. So here are Rule 12B. Here are the 7 defenses. Okay. Lack of subject matter jurisdiction, lack of personal, improper venue, insufficient process, insufficient service of process, failure to state a claim upon which relief can be granted, and failure to join a party under Rule 19. Those are the 7 that you can present on a motion. Now, they filed the motion. I filed a response. They get to file a reply. Then what happens? Well, what typically happens is, since they were the party that moved, it's on them to set that for motion. But guess what they never do? They never set it for motion. And it usually sits at the court for months upon months. But what does this down here say under Rule 12I? Hearing before trial. Crash, are you able to read that for everybody?
It's very fuzzy on my screen. That's why I'm not just sitting there reading it.
All right. If you can't see it, I'll just go ahead and read it. Rule 12I states hearing before trial. If a party so moves, any defense listed in Rule 12B 1 through 7, whether made in a pleading or by motion, and a motion under Rule 12C, must be heard and decided before trial unless the court orders a deferral until trial. So what does that mean exactly? It means that if I ask the court for a hearing, the court is required to give one to me. And if they don't, they have violated my rights to due process as enumerated under Rule 12I. So that means what? It's an appealable issue. This is why Dr. Graves states unequivocally the rules rule. The rules govern everything. So with that, that's where I'm at. Oh my gosh, I'm so sorry. 45 minutes in, and I'm barely getting to our guest, Captain Cross. But
oh no, you're doing great. I am just soaking this up like a sponge because every time somebody talks about this stuff, it is understood differently.
It is. I mean, this is why I love to listen to anything about, court processes, proceedings, things like that, because I'm always learning little things that I didn't know before. One of my favorite things to listen to is the Rule of Law Radio with Randy Kelton and Brett Fountain. Those guys have lots of little insights and things I didn't know before. So this is what's going to happen. They're going to file their reply brief to my response. And as soon as that's done, I am filing a motion for a preliminary pretrial hearing because the court is being asked to dismiss my complaint on a jurisdictional issue. I have a right to a hearing. And I have a right to explain to myself, say, hey, Judge, they're claiming I'm a taxpayer, and that because I'm a taxpayer, I have state law remedy. Nothing in my complaint stated I was a taxpayer. In fact, I unequivocally stated I wasn't, and that I asked for evidence from the defendants that I was, and they could not and would not provide any of to me. So The material issue is, am I or am I not a taxpayer based on my complaint, based on the record? And this is why I want a hearing. I want to get it on the record, and I want a transcript of it. So if the judge says, yes, you're a taxpayer, in this case, dismissed, I'm like, okay, judge needs to have his head checked. We're going to the 10th Circuit Court of Appeals. And I've got the case right there.
The one thing that I want to say is that whatever you claim in your complaint must be taken by the court as true and correct.
Correct.
So they need to provide evidence that what you're saying is incorrect.
Exactly.
So, and if they haven't provided anything to support their claim that you're a taxpayer, then this is where I think this is what I'm understanding your argument to be, is that they haven't done anything that to prove that you're a taxpayer. Therefore, come on. Let's rule on this, right? So, okay. I'll iron out the details, and I'll have to read way more on the rules because I'm not as well versed as you are.
Well,
That's
I mean, it's
absolutely.
Well,
absolutely right.
All it is just reading and being able to comprehend what we're reading. And then I also, I have a subscription to Westlaw. So I go in and I look at what the courts have ruled, what these rules mean. And,
right.
when I look under the motion to dismiss, and it states that the courts should not grant a motion to dismiss under Rule 12b-1 without a hearing. And if they do, they have violated either the defendant's or the plaintiff's rights to due process. So with that being said, Captain Cross, the platform is now yours. Give us an update on where you are. The last I remember, you filed, and I think you were doing an amended completing, if I remember correctly. But fill us in with where you are now and what's going on.
Well, here's the deal. Eventually I put together my little website now, and all my filings are on that website.
Oh, perfect. Which
is pilotgateway.com.
Okay, I'm going to pull it up and I'll share the screen so we can look at it while you're talking.
Yeah, and on the lawsuits tab, you go to that, and it's very basic, really. The website is nothing fancy, and legal action. I'm sorry, legal action.
Okay.
Yeah.
Oh,
now,
wow.
I've got all the filings from the beginning, basically, until today. And the latest that I just filed is that very top one, which is an injunction for language that the company and the union put in the collective bargaining agreement that invades public policy and violates my constitutional rights to a trial by jury.
Okay.
In the defense of my medical certificate.
Okay.
And if you remember, James, I went with the argument of contract law.
Yes.
Instead of it's my body, it's my right, it's my Title VII accommodations, all that. I just did not go that way from the very beginning, from day one, and decided to argue that there are regulations that must be followed, there are contracts that must be fulfilled, and that's how we execute this business under aviation law. And the medical certificate is just rules supreme over everything that we do.
Okay.
So I filed, if you go to American Airlines case, I filed the complaint. They filed their motion to dismiss. And this is where I want to mention something, and that is that the judge helped them with the failure to state a claim by interpreting certain language. If you want to pull that up.
I'm going to. I actually downloaded the judge's order, and I already see problems with this. But yeah, I'm going to pull it up, and you can talk to it while I've got it up here. So
yeah. So basically, what the judge ruled, what I wanted to do, is get out from under the Railway Labor Act, and the Railway Labor Act has an administrative process to resolve disputes over contractual terms in the collective bargaining agreement.
Okay.
A medical certificate is not part of the collective bargaining agreement.
Okay.
It's public policy, and it's actually a right under the Federal Aviation Act of 1958, because the Federal Aviation Act of 1958 states that it declares, it does not create the right, it just declares that we as US citizens have a right to transit the navigable airspace. Well, how do we do that? As pilots, we receive our clearance from the FAA, which is positive law, right? The FAA is positive law, and they clear you to exercise your right in the navigable airspace. Well, that becomes, it's an extension of your right, the medical certificate.
Mm-hmm.
So it cannot be negotiated. It cannot be part of a contract because it's public policy. And to get out from under, the lawyers for the company kept on claiming that the collective bargaining agreement controls my medical certificate. Every chance they got, they would just try and go back to the Railway Labor Act, the administrative process. My argument was very simple, and there's a case that supports it. And it's Arizona Supreme Court. It's Selig Volt versus North Valley Hospital, I think it is, in which the Supreme Court in Arizona ruled that language in the employee manual or handbook is contractual. It's contractual, and companies cannot change those rules when the employee reliably depends on this on the manual to, or it would be to the employee's detriment if they do change the rule. So my argument focused on that as a contract between the airline and myself, where the employee handbook says a pilot is responsible to maintain his medical certificate. And if he's unable to do that, then he would notify the company. Okay, so what the judge did in this ruling, and if you go to, let me see, if you scroll, let me see, I can't remember now what page it was on, but he ruled on the contract. He said, he admitted that language in a manual. Here it is. There it is. That I think towards the bottom, pre-hire and documents and so forth, and it goes towards the bottom. It goes, the court assumes without no, at the top of the page there, James. Yeah. So the court assumes without deciding that plaintiff has sufficiently alleged that the attached employee handbook and flight operations manual are contractual, because plaintiff's failure to allege a breach of any of the terms contained herein or elsewhere is dispositive. Now, how did he justify that?
Yeah. He's saying you failed to allege a breach of contract, but I thought one of your causes of action was a breach of contract.
That is right. So it's the breach of that contract, which is contained in the employee handbook, in which it says each pilot is responsible to maintain his medical certificate. So what he said was that it is only binding on me to maintain a medical certificate. And if you read, he goes at the line 2 in that paragraph, the second paragraph says the attack alleges that American's mask policy breached terms in the flight operations manual requiring pilots. He didn't say responsible to maintain. He started with to maintain a current medical certificate appropriate for the crew position. And he said that is only binding on me.
Yeah, it says these terms plainly impose obligations on plaintiff, not defendants.
That's right, which is not true, because if you read the whole, and words have meanings, right? So responsible to maintain means that they cannot interfere in my responsibility to maintain. Therefore, it is binding on them just as much as it is binding on me.
Yeah, so this amounts to an abuse of discretion by this judge. So everybody's
that's right. So what he did is he created a lack of, or he created a condition where there is a lack of stating a claim.
Yeah,
he ruled that the plaintiff lacked, he did not state a claim, and he ruled on that. Well, he gave them a win with that language.
Yeah.
Okay? By him
He says
interpreting the
right
language.
here, he says right here, plaintiff's arguments to the contrary are unavailing. He argues that any imposition by American of any medical procedure is ... a violation of the very term of the employment contract. This argument is utterly baseless. Okay, why?
Which is BS, because that's exactly what it is. They
It says that-
cannot impose any medical procedure on me because they cannot be party to the contract between myself and the people. See, the medical certificate is a contract with the people.
Yeah, see, what this is, guys, is this is a violation. And this is something you might want to consider if you get an opportunity to amend your complaint again, Captain Cross, is you need to allege a violation of your right to contract with your passengers. This procedure violates an unlawful attempt to let me just make sure I'm phrasing this right.
Impaired the obligation.
Yes, there you go. This imposition impairs your obligation and your right to contract with them. They are trying to insert themselves into a contract in which they have no business being involved in because they're not a party to that contract.
That is exactly. So if you go to this case is fully briefed now at the Ninth Circuit.
Yeah. Okay. Let me download your brief and we'll take a look at that. So.
And if you read in the brief, that's precisely what I said. Not as eloquent as you would state it, but
in your opening brief.
In my opening brief, absolutely. Okay, and then in their reply brief, here's the beauty. So he gave them a way out. Okay. The judge gave them a way out, right? So
the judge at the trial court. I just want to make sure.
At the district court, yeah.
Gotcha. Okay.
In his statement and reasoning for failure to state a claim, he gave them a way out. So he interpreted the language as he saw fit to kick it out of the courthouse, out of his court. The beauty is, in their reply brief, their lawyers say that Captain Saliba, I'll have to find out how they exactly phrase it, is responsible. Yeah, they say Captain Saliba is responsible to maintain his medical certificate. However, they believe that I can comply with their policies at the same time.
Yeah.
Can I interject real quick?
So, please do. Real quick, Crash, just so for my listeners that you guys may remember this, but Crash is also a certified pilot. She was with the Air Force.
No,
Navy.
Excuse me, Navy. I apologize. How dare me? Oh my gosh. I'm so sorry. She was an even cooler Navy aviator. I apologize.
And I'm also dealing with this stuff with my husband's career right now. But what I want to give some context to is the contrast here. You know, people look at this and they're like, oh, whatever. You know, you go and you get your medical and you have a certificate and you good. However, you have to break this down into simple terms of this is a medical intervention, whether you talk about this or this, it is a medical intervention. And just because there's speculative assumption that it is beneficial for whatever reason via public policy or whatever bureaucratic troll decides that this is what needs to happen, that does not actually mean that it is beneficial to the individual. Period. Mm-hmm. So when you have a responsibility towards not only yourself as the pilot, but the passengers behind you and your co-pilot to uphold your medical, that is your personal responsibility. That is not a group think moment. That is between you and your doctor and your common sense as to what you do on the day-to-day basis to maintain your health and integrity in order to maintain flight status. So if you go into a flight and you're undermining your common sense of what you need to do in order to maintain height, like the and mental acuity in order to operate that aircraft at the safest possible, level to keep everybody, on time, safe. And if there's an emergency procedure, there's not something impeding your ability to do that. you're not tired and fatigued, you don't have a headache, and you're not doing something intentionally to contribute to getting a headache, being fatigued, or having anything in the way, that is your responsibility. We're not allowed to just go and take a Benadryl and then go on the aircraft. We have limits for what we're supposed to do. So we cannot allow any entity to come in and tell us what we need to do in order to maintain our health to fly as a group. That is.
Wait a minute. You mean to tell me that showing up for work drunk is not good?
I mean, it's fun, but I don't recommend it.
I mean, I'm making a joke, you guys, but I mean, you probably have seen in the news a while ago, a pilot showed up plastered, and he thought he was going to fly the plane.
Okay, so drunk is actually
That's
really
exactly what she's talking about.
And this is let me jump in here, James. And this is where there is thanks, Crash. Let me in. There is in the regulation, in the law. Okay, there are regulations that tackle somebody like that. Okay, so in one of my I think it is in my brief here where I described to the court clearly how this whole thing works.
Yeah,
and I described to them that up to the point that the pilot checks in for his duty, it is completely his response. It's always his responsibility, but nobody can tell him what to do at all.
Yeah.
Up to that point, okay, he is the ultimate person who makes that decision to sign in for duty. I'm fit for even if they examine the pilot all day, and then he gets behind the controls, it is still his decision to say, yes, I am fit to go fly. They can't force you to do so.
I'm reading it right here. It says safety is no accident. At the pinnacle of the equation of safety are the pilot's skills and health. No matter the skill of the pilot, if he is not healthy, the equation fails.
That's right.
You're not wrong. Yeah,
that's right. So now, but here's the trick here's the law that says, okay, you checked in, you're in uniform, and you're going to go fly an airplane. Anybody, it doesn't have to be the company. Anybody, a law enforcement personnel or anybody in the terminal sees you wobbling, walking to the gate, they think you're intoxicated, they can force an examination of the pilot.
Yeah.
Right? And then you must submit to the examination. So there are rules and regulations that cover that, but there's nothing, absolutely nothing that says a company may impose any medical procedure or treatment. Not even the FAA does that because of contractual obligations and because of risk assessment and whether they can assume the risk or not. They are the agent of the people. They cannot assume the risk on behalf of the people and contract with the pilot at the same time.
Yeah,
I discussed that in there too.
Yeah, I just want to point out, you put it right here where you state Article 1, Section 10, Clause 1 of the federal Constitution, which it talks about that no state shall pass any law impairing the obligation of contracts. And then you state here, such as in this case, where a contract between a pilot and the people is subject to FAA rules and regulations, or that an agreement between a pilot union and AA, in this case is American Airlines, not Alcoholics Anonymous, okay, people.
Right.
May not invade public policy. In this case, and in line with my duty, I am executing contracts with every signature I affix to a document. I am free to execute such contracts in accordance with public policy and in line with the contractual language in the employment agreement. In addition, I may not be coerced or forced into contractual agreements in violation of the federal regulations and public policy. The above statements demand supporting language from this circuit. Good.
Yeah.
So I assume on this one, you're awaiting a ruling from them, correct?
Yeah, this is fully briefed at the Ninth Circuit, and I'm waiting on them either to go for oral arguments, or they might just rule on it. I don't know how that's going to go.
Okay.
But yeah, so it is a contract. It really is a contract. So to avoid getting into any of the medical discussion, because in my other case against the union, the judge basically ruled that I'm not I'm not the one who can make a decision whether restricting my breathing is acceptable or not.
Mhm.
I'm like, really? So when
Uh,
I filed a motion for reconsideration, guess what? He couldn't rebut it. He couldn't rebut it. So his comeback was, "Oh, you are quarreling with the court. Dismissed, or what do you call it? Denied. Motion denied.
yeah.
Because now I am quarreling with the court because I corrected him and I told him exactly how the rule applies, and he didn't like it. He just did not
So-
like it.
So that's what court is for.
That's right.
Court is for quarreling.
Because he did not have any law to support the statement that he made, which is
Yeah.
he can't support it. There's nothing that he can say to support it.
Oh, I love this right here. By the way, there is, and this is working in your favor, Captain, there is case law from the Ninth Circuit that states that private actors who are aligned with state directives are considered state actors under Section 1983. Because I just pulled this up from the court's order where it says Section 1983 provides a civil right of action, but only against those acting under the color of state law. He says APA is a union, and generally unions are not state actors; they are private actors. If they are enforcing public policy on the directive of the state, they are considered state actors under Section 1983. And there is Ninth Circuit Court decisions that affirms just that. Matter of fact, I don't remember off the top of my head the name of the case, but it was a I want to say a retirement home of some kind. The people sued because their dad died, and they said that you guys put him in danger of this, and they said, well, we were just doing the directives that the state had, and they sued them under 1983. The Ninth Circuit came back and said, no, you are liable.
I think I know which one you're talking about.
Yeah,
And
I think we talked about it last time, if I remember correctly.
yeah, there's so many things I remember now. I have 5 lawsuits going on. Okay, I did not include one on the because it has to do with a settlement agreement that I made with the airline way back in 2005. Okay, but luck of the draw, I had the same judge on that one as the very first complaint that I filed, Logan, Judge Logan, right? And he ruled that there was no violation of the settlement agreement or the contractual terms of the settlement agreement. But here's the beauty, and I'll send you the language. I'll send it to I'll send it to you. I think I have your email.
I believe you do. Yeah, but
if I don't, just please send it to me, just in case I don't. But here's what he ruled. He ruled that the language in the agreement was unambiguous. All right. Here's the language. Here's the language. It said that the company will provide me with a letter of their policy against non-discrimination.
Double negative.
That's right.
Do you hear that? Against. They have a policy against
non-discrimination.
Non-discrimination.
Now,
That means they're for discrimination, just to
I admit now,
grammatically.
listen to this. I admit that I have read it many times and I never really paid attention to it. I always read against discrimination.
mm-hmm.
And then after it was dismissed, and I'm thinking, why am I going to appeal this? This is just not going to go anywhere, And then I got out of the shower and it hit me. I'm like, oh my God, let me go read it again. So I read it, and sure enough. So now that creates ambiguity in the language of the contract. So now we have to go look at the extraneous evidence to see how and why we arrived at that agreement.
You could also argue the void for vagueness doctrine.
What is it?
The void for vagueness doctrine.
Uh-huh.
So there is a doctrine that applies to any statutory law that if it is vague and ambiguous, that two reasonable people cannot come to the same conclusion, that the law is void for vagueness. It has no effect. You could do the same in contract law too, because generally speaking, if there's any ambiguity in a contract, it's resolved in favor of the non-party who wrote the contract. So, for example, if you didn't write the contract, the other party did,
They did.
and they put the ambiguity in there,
Right.
the courts resolve that in your favor, not theirs.
Ah,
Does that make sense?
yeah, that makes sense. Yeah. I'm still waiting for that letter. They're supposed to provide me with a letter of their policy against non-discrimination. I don't have that. I don't have that letter. I have a letter that states they will not discriminate, but I don't have a letter that says they are against non-discrimination. So therefore, there is ambiguity. So they wrote the contract. Okay, is there a code or where did you get that? Where can I find that, James?
So if you go on to wherever, I don't know what you have access to, if you're just going on to like Google Scholar or if you're going on to Westlaw, just go into Google Scholar and search void for vagueness doctrine and you'll find it.
I got it.
Yeah.
Okay.
I mean, it went all the way to the Supreme Court. So the United States Supreme Court issued, this is what void for vagueness means. And basically it's like what I just said. If two reasonable people cannot read the statute and come to the same conclusion, then that doctrine, then that statute is void.
Okay. Yeah, because I have not written my brief on that one yet. It's due on the 29th of this month. I've got a few things to do before I get there. So,
hey, Captain.
But yes.
I have a call in. Somebody wants to see if they can my phone on the mic to help explain stuff.
You skipped.
If that's all right. To see if this works. Okay, I want to see if this works. Hold on. All right, go ahead.
Okay, how am I coming through?
Clear.
Everybody able to
Who
hear
is
me?
it?
Good.
It's a
Yeah, we
pilot.
can hear you.
We'll just say it's a pilot.
Okay.
All right. We got another pilot. Awesome.
So can they hear me? Or am I...
Yeah, we got you. Go ahead.
Okay, so you guys have kind of touched on it around the perimeter, but you need to directly explain, especially to anyone who's not a pilot, that through the collective bargaining agreement, through the FOM, that the company can require us to have a first-class medical certificate because that's part of federal aviation regulation, which is a federal statute. And aviation has regulations in place that restrict us generally when it comes to substance abuse and alcohol, things like Benadryl, as you stated.
Darn it.
General aviation policy does not explicitly state things we have to do. The things we have to do is liaise through aviation medical examiners who are representatives of the federal policy, the federal government, the three-letter agency. So anything specifically we have to do, like an example would be sleep apnea, using a CPAP or a dental device, or heart medication for someone who has a medical condition. That is prescribed through an aviation medical examiner, through the aviation medical board with the FAA. This trumps state policy, local policy, unless it's written in as a law through the FAA as a federal aviation regulation through the aviation medical board. Then it is not, the company can state nothing that we have to do or take, medically speaking. There is no precedent. So essentially, the company trying to say you have to do something medically, as in you have to wear this, you have to take this, you have to receive this inoculation. They have no grounds for that. That we select as our flight time, and the rules and regulations set forth by the FAA and reviewed by the aviation medical. The company, the state, have absolutely no say. The only say they have is in the collective bargaining agreement and saying that we must have a first class. Therefore, they have no grounds in the contract to say you have to do anything.
Yeah.
At least on the grounds of aviation medical requirements.
All right. So with that cleared up, Captain Cross, do you want to jump into your latest filing?
No,
or you want to do that later?
Yeah. This is very good. What he said is accurate, is absolutely accurate. But what the companies have done is they were able to secure the consent of the pilots.
Yeah.
This is why I focus on the contract law, because once they they secure the consent of the pilot, that's it. You can do. It is your right to contract, right? This is a constitutional right to contract. They secured the consent of the pilots, and the pilots made that decision. The FAA cannot tell you what to do. They just can't tell you. They're there to examine you, and if you, and he's the pilot is right on in the fact that you have to seek the treatment if you want to continue to exercise your right to transit the navigable airspace. You ask the FAA, hey, is this okay? Is this approved by you? And they'll say yes or no. It's that simple. They're going to either approve it or not, depending on what their knowledge and what their standards are set to. But nobody can tell you, because they cannot enter. Nobody can demand any treatment because they cannot enter into the contract.
Yeah.
And in my case, the argument is that there's already a contract where they admitted that it is my responsibility to do so. So they already stated that in their brief. That's it. We're not going to go back and say, oh no, but you can still maintain the company policy or comply with the company policy. That just does not work.
No.
But here's, so the caller, the pilot is again, he's right on. And this is why the companies now are coming to the unions to insert language in the collective bargaining agreement that would disallow them to take the company to courts.
Yeah.
Do you want me to pull that up?
And try, yeah, that would be great. And that would, here's the deal with the collective bargaining agreement, or your rights. You can waive your rights. Okay? You are not allowed to violate public policy. It's very complicated and it's very diabolical what they're doing. Okay? They are coming across as though they have authority, but they don't have authority. So when I asked them to show me the authority, they didn't have any authority. I said, I'll do anything you want me to do. Just show me where you have authority. But when you do that, then you have to sign all these contracts. You have to sign my medical. You have to sign the release of the flight. You have to sign my fitness for duty. I'm not going to be able to do that. And they said, oh no, we can't do that. We can't take that away from you. So
before we jump into this, Captain Cross, we talked to somebody this week that read their contract and were excited about it because they don't understand what we're about to explain. So
okay,
go ahead.
Here.
Yes, this is the language that lulls pilots into believing that they actually do have protections. Okay, so this language was inserted in the 11th hour after 4 years of negotiations with the airline. In the 11th hour, about 7 days before the voting started, in a very obscure section of the CBA. CBA is the collective bargaining agreement.
Yeah, would you mind reading this? Because we do have a lot of people who listen to this show. Would you mind reading this for us?
Yeah, let me before I read that, let me say
sure.
So the airline and the union arrived at tentative agreements, and they were amended 3 different times, and on the 4th time they inserted this paragraph, and the company came with $1 billion in improvements in the contract and inserted this paragraph in the CBA. Nobody saw this. Very few pilots actually saw this, and for the most part, only because I was talking about it. I brought it out into the public, and I was telling the pilots, this is not good, because now if you vote this in, you are actually violating your co-workers' constitutional right to a trial by jury. because now you lock them. Any dispute over this language has to be resolved under the Railway Labor Act grievance process, which may end in binding arbitration. And binding arbitration, the arbitrators will not interpret law. They will only interpret the language in the contract, because the language in the contract is contract, and contract is law.
Yeah.
They will not interpret public policy.
Yeah.
That's not their.
Every terms and conditions also includes that exact same language. If you read, like, for anything, if you want to download an app on your phone, if you want to get a new cell phone, if you want to buy a new product, they all say that you waive your right to a trial by jury and only agree to their arbitration.
That's right. So the pilots who signed this contract on August 21st, they waived the right to a trial by jury and the rights of everybody else. The clever language in this section in the contract says medical protections and qualifications. So under paragraph 1, it says the company may not require a pilot at any time to undergo any medical procedures other than those required by the FAA to maintain a first-class medical certificate. I just finished saying the FAA does not require any medical procedure or medical treatment. All they do is conduct an examination, and they authorize certain procedures if you choose to have those procedures to maintain your medical certificate. But you have to make that decision. You can't expect the FAA to say, no, you got to have that in order to get a medical certificate, right? So you just meet the standards. That's all they are concerned with. So why do we have a language like that? That's already plain clear. It's clearly plain to us that the FAA does not require anything. Why have that line in there?
Well, here's what my thought is. Look at, I mean, you finish reading to maintain a first-class medical certificate. There's a comma, and it says unless required elsewhere in this agreement. Guess what that statement right there just did?
That opens up a whole other section underneath that statement.
Well, not only that, it just nullified the preceding sentence before it.
That may be true, but let me tell you why they have that in there. Because there is another section in the CBA that allows the company to examine pilots for fitness. So if there's let's say a pilot is abusing his sick leave, he's calling sick every weekend, calling sick over Super Bowl, calling sick on the 4th of July, then, well, he must have a chronic illness. Yeah. So if they want to examine him, then they have to go through procedures, right? So that covers that. Okay, I buy that, not a big deal. But here's the problem. It says medical procedures. There's a medical procedure, and then there's a medical treatment. Two different things.
Yeah. So
if the company says you've got to take this medical treatment, whatever, vaccination, let's say, okay, well, that's not a medical procedure. I talked to a doctor, and she told me that is a medical treatment. It's considered a medical treatment. So when the company says, well, you got to take this medication, and you say, well, no, wait a minute, let's look at the contract. It says you can't demand any of this stuff. They'll say, read it again. This is not a medical procedure. This is a medical treatment.
Yeah.
So what that does is immediately invokes the interpretation and application dispute between the parties. And
it becomes a word. It becomes.
That's right. How do we? They will tell you. The company will tell you. Look, this is how we read it. You understand it differently. You are welcome to grieve it, but you must comply.
And you can't go to court.
And you can't. If you go to court, the court will say, we don't have jurisdiction over this because there's an administrative process under the Railway Labor Act that you must.
It's a contractual dispute now.
Yeah,
that's right. So this is what they wanted to do. So people like me who take them to court would not be able to do that anymore.
And they're also
Then
going to
they have-
have that word game where, like, for this part of it, they could say that it's an emergency public policy and has nothing to do with the medical procedure aspect of your contract.
Right. And then it's a dispute.
Right.
It's a interpretation and application dispute that must be resolved under the grievance machinery. Courts like to call it grievance machinery under the Railway Labor Act. So that in and of itself alone is enough to keep the pilots from courts.
Yeah, that's a major issue right there.
So James, yeah. So here's what I said earlier, where it comes into play, and that is, so let's say, okay, I disagree with the company, I grieve it, and I take it all the way to arbitration.
Yeah.
The arbitrators cannot rule on public policy, on the law, because I'm saying this is my medical certificate that you are invading, and they're saying, no, this is contract, you got to fulfill the contract. So you go to arbitration, the arbitrators say, wait a minute, I'm not ruling on the public policy, I'm not ruling on the legality of your medical certificate, I'm just ruling on the language and the contract.
Mm-hmm.
That's been cited in many cases. One of them is Norris versus Hawaiian Airlines.
Yeah.
And there are many more citations where the courts clearly state that fact.
Now, even if the person who wrote this contract wrote it with good intentions, the legal team that's there to support the contract, or the company and their shareholders, is going to rule in favor of.
Absolutely.
Oh, absolutely. They want control.
In the individual.
They want control, and they want
Every
to stay
time.
out of the courts.
Yeah.
They want control, and they want to stay out of the courts.
Every single time.
So
Yeah, I'm here to. Sorry, go ahead, Erica.
It seems like the only answer to this situation is to just not work for these people.
No.
Good luck finding pilots now, you guys.
The answer is what I just did, which is filing a complaint for an injunction to remove the language from the contract. Because this is public policy. It's never been in any contract that touches a pilot medical certificate where they can dictate any medical procedures or treatments. It's just never existed. And now just putting it there is codifying it and making it contractual.
Yeah.
And that's a big problem. Okay.
Yeah, that's what I was gonna say. I mean, if you're, again, no one can force you into a contract, right?
No.
So if they if your union, your association, if they put something in a contract that you don't agree with, well, obviously your first step would to tell them, say, hey, I don't agree with this, guys. I'm not signing this. They're like, well, you're going to, or you're not going to work for us. Okay, well, let's see how well that works out for you when I file an injunction.
So
and that's precisely what I did. Is I sent them an affidavit, a notice of affidavit and demand not to have any language, and I declared my right to trial by jury. I said, I'm not giving that right up. So you can't put this language in there and deprive me of my constitutional right to trial by jury. The company did not respond to that at all.
That last line is also very disturbing. We haven't touched that yet.
I was just going to piggyback that onto what Erica said, because what they really want is they want anybody like Captain Cross or Erica or Crash or James to not work for them anymore. And they want to bring in new hires that are either in the communist movement or in the yes sir movement and just happy to collect a paycheck and do what they're told. That's their whole purpose. It's a slow infiltration and takeover. And then they get what they want. Yeah. So yeah, read the last line there.
Yeah, so this provision does not apply to pilot new hire requirements.
Right.
So the union argues, well, we don't represent these guys, so what do we care? So it's we can't. But just the fact that they put that provision in there, okay, is giving the airline. They're conferring authority in the airline. They're saying that the airline does have authority to impose new hire requirements on the pilots coming through.
Right.
They're if they didn't put that in there at all, well, you know, if the company has that authority, why do they need to have it in a CBA?
Yeah.
Which is what I stated in my complaint. If they do have the authority, they don't need that. They don't need that term in there.
Yeah, this
Yeah.
explicitly opens the door for an airline to dictate a medical intervention for new.
Crash, your internet keeps coming in and out, but I think we get the gist of what you're saying. So
basically, the airlines created a new medical standard that is
Yeah.
different than what the FAA has created.
yeah, see, and if we actually lived in a society where these three-letter agencies were created with we the people at the best of intentions, someone at that three-letter agency would be doing what Captain Saliba is doing. They would be filing the lawsuit. They would say, no, we can't interfere with your right to contract, but this violates everything that we were created to do. And again, it's a contract law issue. It's a statutory law issue. Let those liars that live and die in that world go ahead. Be my guest. But you're right, Captain. I mean, it does not. No, hold on a second here. I am not waiving any of my constitutionally. By the way, I do want to just clarify one thing, because you'll see this from judges, you'll see this from attorneys, where they'll state that we have statutory or constitutional rights. How many times have I said this, Justice?
Every time.
We do not. I repeat, we do not. We do not have statutory or constitutional rights. We have constitutionally secured rights.
Right.
You have on your, I was just looking at it on your website, Captain, where under the section on the law, you have the 9th Amendment, which states that these enumerated rights shall not be construed to or deny other rights retained by the people. That amendment is one of the most important amendments ever conceived. And I said this previously. I wonder if Crash knows the answer to this question. Crash, do you know when the founders got together after they had written the Constitution, they got back together to do the Bill of Rights? Do you know how many rights were initially proposed in that Bill of Rights?
I don't remember how many were the initial, but
2, maybe 1.
No, it was a lot. It was a lot more than that. Erica, what was the number?
I don't know. I'm just guessing hundreds.
Okay, let's see if you remember. Justice, were you on that show that we did?
No.
Okay, it was 157.
Yeah.
Wow.
157 rights that they wanted to enumerate and put in the Bill of Rights. But James Madison, being, not only did he have a good name, I'm biased. Can you tell?
I do remember that. Yep.
Yeah. Not only did he have a good name, he also had like, hey, you know, if we put this thing, the state's just going to find a way around it. Eventually, the government's going to find a way around it. We need a catch-all. The 9th Amendment was the catch-all.
Mm.
So this. I'm just going back to this, and I put this in my court briefings, and I have no problem, Captain, calling out judges who are clearly in error. And if the judge issues a ruling in my case that says, well, your statutory rights or your constitutional rights, I will throw it right back in their face and say, again, there is no evidence before this court that I have statutory or constitutional rights, because I don't. I have constitutionally secured rights, constitutionally guaranteed rights, of which every member and officer of the court has taken an oath and has sworn to uphold.
That's right.
Yep. I'm not one of those guys that's going to go show me your oath of office, because again, that's the wrong argument. I'm going to be like, you are required to take an oath. It's presumed you have taken an oath. And if you haven't, then that's your problem, not mine.
hey, we have he called back in. So
Wow.
let's try this.
We don't even have a call number, and this is fantastic.
I have a call number.
She's got a pilot society going on over
Yeah,
there.
go ahead.
All right, you're on.
Okay. I'm listening in, but I don't have it on right now. I don't want to keep back that quick. I just wanted to put a stamp here, not just on the specifics of the argument, the arbitration in regard to contract law, but kind of put an emphasis on the argument, is that not just pilots versus doctors. many of us are held to a high standard, especially when it comes to for duty, when it comes to the medical standards that dictate our ability to do our jobs. And these standards are higher than the general populace. And often we have to go through more rigorous trials and examinations in order to simply go out and be allowed to do our job, whether it's federal or state statute. And most of these things that we're talking about, whether they be vaccinations, masks, extra medical examinations, they're being imposed on people who are stewards of public safety. Because there's no avoiding that being an airline pilot is part of public service job. And we are stewards of the people that we care for, regardless of your opinion on automation. This falls into many other industries that we're speaking about. And so when they're coming after this contract law and doing this through manipulation of unions and desired increased income, that they're coming after the people who are held to a higher standard, not just the standard of performance and stewards of public safety in industries such as that, and including because those we give up some of our rights in order to be able to maintain that higher standard of medical statutes and also our ability to perform the job at a higher level. What would be considered the general populace? For example, less than 20% of America's youth are medically able to qualify for military service. So the fact that they are coming so aggressively or subversively through contract law, through corporations, take those rights away in order to make them more difficult or to comply with something that we're saying no, or we find that in question or in a level of experimentation we think would be unsafe, to use this as essentially a testing. If you're using this as a testing group for something that's unproven or something that is in question by a large amount of the populace and inflated by bureaucracy and government, then you're actually putting the public in danger.
Yes.
Putting them in danger if you're taking the stewards of public safety in multiple industries and military, essentially making us the lab rats for things that are unproven and are essentially being pushed under a political agenda.
Good point.
It's very unethical and very unsafe. But again, it comes down to the basis of they're going to use law, contracts, and unions to follow the politics and not common sense. We should be the last group tested, not the first.
Yeah.
Sorry to keep going.
Yeah.
No, wait.
Oh no.
Hey,
The problem is that Crash's internet is breaking up, and Crash, can you kind of sum up what he said? Because
Yeah, I can do a summary real quick.
I mean,
So
is
what
he
he's
disagreeing? He's not disagreeing with what I'm
no,
saying.
he's
Okay.
he's not disagreeing. What
It's
he's
hard to pick it up.
he's saying that we are the stewards of public safety. So anybody who is in an industry that's either transportation or public health, actually like doctor, nurse, somebody who is your hands and your knowledge help keep the public safe. Anybody in that sector that falls under that umbrella, also including military, anything that protects the public, very last of any type of experimental something that could be harmful.
So
exact
does that
same
make sense?
piece that we missed the first time, we missed this time because your internet went out again.
So you said anything that protects the public, and then it stopped, and then you said last. The next
yes.
one.
Okay. So we should be the last to be part of the experiment because you should know what the results are going to be before you subject everybody. Because if we get harmed and start dropping from the sky, that harms a lot of people, not just ourselves.
Look what's happening.
I don't see any evidence. I
know what's happening. That's why we brought it up.
I haven't seen any evidence in the last 3 or 4 years that any of these NGOs, large bodies, government, or anything have any interest in protecting the public.
No.
So that's why they're
they
picking
don't.
on you guys first.
Yeah. I do want to bring something up real quick, Captain. So I mentioned one of the sources that I really enjoy listening to a lot is the Rule of Law Radio with Randy Kelton and Brett Fountain. So Brett actually just reached out to me on Telegram. He's listening in right now. So, hey, Brett, shout out to you, buddy. He says that he just wants to make sure we understand this distinction. And I'm just going to read this word for word because I don't believe this is the case. But Brett says that he says he's seen, when he says he's referring to you, Captain Cross. He says, Captain Cross seems to believe that we have a right to transit the airspace but he might not realize that a right cannot be converted into a privilege and taxed and regulated. And that is the truth. The state cannot take a right and convert it into a privilege and tax it and regulate it. So he does say the commercial privilege is separate from that right. If you are engaging in the regulated activity, that's not the same as exercising your right to transit the airspace. I suggest it might be good for him to keep that distinction clearly in his mind as he formulates his position. So this is...
I recommend that contributor try to fly the navigable air.
No. Here's
under any federal regulations and see how that works out for him.
Hold on, Crash, you skipped out again. Say again.
I recommend that contributor go ahead and try to navigate or fly through the navigable airspace in the United States without following any federal regulations and see how that works out.
Right.
No. Let me make a comment here. There is a distinction. There is a distinction. Okay, and that distinction is addressed in the Federal Aviation Act of 1958. So if you go to section, I'm gonna cite the regulations. 49 U.S. Code, paragraph 42112. Okay, so as a private citizen, you exercise your right by getting your pilot certificate and your medical, and you go fly on your own. You're just flying. You're exercising your right.
Yep.
Now,
but you still have to be. You're still under federal regulation.
Yes, you are.
So
yes, you are, because that's the Aviation Act of 1958. But 49 U.S. Code 42112 then says that we are then providers of transportation to the rest of the populace, and that falls under the economic obligations, or I can't remember how they labeled the section, economic responsibilities, I guess, of air carriers. This is where you get into the commercial side. Okay, and they refer to the pilots as providers of transportation.
Right.
Okay, then we are in the commercial realm in that arena. Yes, I have made that distinction in my filings.
Good.
Which then there's an air carrier obligation to maintain compensation for the pilots and co-pilots who are providing transportation. So we're not just mere workers or employees at the airline. We are actually creditors. We are providing a service to the airline.
Yes.
I like to refer to us as creditors.
And a privilege to the society for them to traverse the navigable airspace.
We're making it possible for them to exercise their right.
Yes.
Right. Yeah. Here's the distinction. Okay. And this is where I feel like, I didn't want to get off in the weeds here, but here's the distinction. The Supreme Court has stated unequivocally, we all have a right to travel. Now there's numerous methods for how we travel, right? We can walk, we can ride a bike, we can ride a horse, we can use your car, your truck. You can get on a train, you can get on a plane, you can get on a boat. There's any number of ways that you can travel. So the Supreme Court has stated that a private citizen, a state cannot convert a right into a privilege and charge a tax for thereof. So this goes more to your right to being able to drive your car. And Brett, by the way, is the best in the business. So I suggest you follow him on Telegram if you have questions on, well, do I really have to have a license to do all these things? I'll let you guys determine that on your own. I've told you before why I choose to, because I don't want to be harassed. But to each their own.
Yeah, technically you don't have to, but it's a fight.
Exactly. It's a fight. So now when you get into things like where Captain Cross and where Crash are talking, you're talking a big commercial airline where there's 200 and something passengers on board. I think we can all agree that we want to make sure that whoever's operating that aircraft is A, certified to do it, and B, is operating it safely, so that I can ensure that they're protecting my right to travel, to navigate the airspace. Because you're right, Crash. If I got into a cockpit, I wouldn't have the clue what I'm looking at. Wouldn't even know how to turn on the propeller if I'm in a prop plane. Wouldn't even know how to do that. So,
well, I actually have a different, how do I say
Perspective?
it? Perception. I don't know. I don't agree necessarily with the conclusion that
Why is it every time her
just
important
because
things
you
get
are
cut off?
here because of the same reason.
So
You don't
have
have.
to
I
repeat
don't
it.
feel like you have the right to just drive because you're here. I did. I don't feel like you have the right to drive just because you are here. I think that the driving licensing is to ensure some level of safety and knowledge. But I am 99% sure that in the state of Mississippi, they're giving out handicap licenses if you fail the test.
I'm here to tell you it's not just it's not just in Mississippi. Okay, that's everywhere.
Okay.
So yeah, I mean, you're right. I mean, like I said, we all have a right to travel. How you choose to exercise that right, that determines what happens there, right? Because again,
and your abilities.
Exactly. When you purchase an airline ticket, there is a contract with that, right? I mean, it's why am I drawing a blank here, Captain Saliba? What's that called? It's the contract, not the carrier contract.
Contract of carriage.
There you go. Contract of carriage. Yes. There's a contract with that, right? And it states, by you purchasing this ticket, this is what you're going to agree to do for us. And by you purchasing this ticket, this is what we agree to you. We agree to get you from point A to B as safely as possible. We agree to ensure that the employees are certified to do so. All of these things. And this goes back to the ultimate argument the captain is making, which is contract law. Because of the fact that we purchased the ticket, that contract is between us and the people flying that plane. I mean, guys, I travel a lot for my business, for work. I travel a lot, and I can't tell you how many times I can think of one instance where I was on a flight from Atlanta to Salt Lake City. I'm not kidding you. We were seconds from touching down, and something happened that the pilot felt was unsafe to touch down, and we jets full throttle. We went right back up, and we ended up landing at another airport. And ultimately, we found out it's because there was some heavy crosswinds coming in, and he felt that if he tried to touch down, that the crosswinds would potentially cause us to crash. So that pilot made the split-second decision to fly right back up in the air and go land at another airport. Those are the decisions that we're entrusting these people to do, and they're, God bless them, but the captain is not wrong. This is not going to be an easy fight. I do want to just inform you, Captain, that, and you're seeing it already, the likelihood you're going to get a positive redress in the district courts are slim to none, which you're already seeing. These decisions that are being rendered by these judges don't make any sense whatsoever, at least from what I can see. And it's mind-boggling how they come to these conclusions and how they're giving these corporations they're giving them a bypass. They're just giving them a free pass. So you need to stick to your guns. The good news for you is there has been a changing of the guard at the Ninth Circuit Court of Appeals, which has traditionally been the most liberal circuit court of appeals in the country. But luckily, there has been a changing of the guard. There's good decisions coming from those justices, but even if you don't get the decision you're looking for, your case is strong enough and it presents an argument that is strong enough that the Supreme Court of the United States would need to hear it and more than likely would take it up.
And pilots listening to this, if enough of us actually understood what he's doing and stood with him and petitioned the unions and took a stand with him, then he wouldn't even need to go that far. The pressure from us as a whole would be enough. So if you go to pilotgateway.com, you can look at all of his legal proceedings and paperwork. And if we could actually organize just enough of us to just say, hey, this is a great thing. We all need to stand together on this to protect.
Yeah.
There wouldn't be, he could actually, start flying again and stop fighting our legal battles for us.
Yeah.
Right. So
can
I piggyback on that?
Yeah, real quick. And then we gotta wrap things up. We're coming up here on 2 hours. Don't get me wrong. I love I love these long shows like this. I just want to make sure that the information we're giving you guys, and when I say you guys, it's not just those of you who are on the screen here with me, it's people watching, people listening. I hope that this is relevant. Please let us know. Like I said at the beginning of the show, I do everything in my power to help you. And I'm getting on my soapbox again, but if you refuse to listen to the information I give you, that's your problem, not mine. Do not make it mine. Kate, back off my soapbox. Go ahead, Justice.
Okay. So Captain did a show with Crash and I at the beginning of the week on our channel, and we talked about different stuff, and we delved more into the law here. But at the end of the show, we had a talk. And can you tell people for how long you have not worked now?
Since August of a little over a year. Well, I have not flown since December 6, 21.
Okay.
And I've been on unpaid leave since August of last year.
Right. So
a little over a year.
And just like Crash was saying, if you really knew the magnitude of what he's doing, he's standing up against these airlines for the basic duties so many pilots should have and kowtowed. And, he chose to stand with integrity against what was being done, not only to the pilots, but the safety of every passenger out there. Because every passenger that's flying is flying with, pilots that are, restricting their oxygen and so forth. And I kind of bullied him into taking donations. I said, the same thing with James. People have reached out and said, we don't know any legal stuff. We don't know what to do. Can we just donate some money? So I asked him if he would just set up a donation. And if somebody wants to donate, and you don't have to push it. You don't have to advertise it. But there is a link that he set up, or he had his son set up on the Pilot Gateway to help him with the legal costs, because he's not just fighting for himself. He's fighting for everyone. And if you Google his name, you can find plenty of articles with details. Some of them are skewed and some of them have false information and all that stuff. But I would implore you, if you can't join a group, if you can't fight in any other way, and you can donate something to his cause to help him push this through, because we all want him to win, because he's fighting for all of us. We don't want our country's airline taken over by the communist regime. We're going to have to censor this show and probably split it into.
Yeah, I think so. God bless you, Justice, for being able to do all of that.
Thank you, Justice.
You're welcome. So,
I would just say, how is what the captain is doing, standing on your morals and your principles, even though it might be against what the law might state or say. And here's the thing. I mean, there is no law against what these people were trying to do. There's no law for it either. But how is this any different than what was going on during the civil rights movement? How is this any different? And please do not take this out of context. I'm not comparing the captain with this individual, but I'm just saying there was a brave woman who refused to sit at the back of a bus because it was morally wrong, even though the law said she had to.
Actually, it was a teenager. It was a teenager. And
Exactly.
then she staged it for the publicity, but all props go to the teenager.
You know what, Crash? You just have that's it. She's not coming on anymore. That's it. Done.
Oh no. James.
Oh my no, I'm just teasing. I love you. But
Crash is amazing with details. She's got an amazing.
I know, but the point is the same, right? I mean, at the teenager, whoever, if it was a different individual, I'm just saying they knew. Hey, this law is wrong. This violates. I mean, the Constitution says all men are created. I mean, the Declaration of Independence says all men and women are created equally. So if we're all created equal, then why is it that I'm required to sit back there because of something about me? And that I'm not saying that's the same situation here.
Her name is Claudette Colvin. Sorry.
Claudette Colvin. Thank you. So I'm not saying that it's exactly the same, because it's not, but the principle is the same thing.
Exactly.
The captain is saying, hold up, you're asking me to do something that violates my principle and my duty to my passengers. I cannot do that in good conscience. And he was put on unpaid leave. He's now been terminated. Did they terminate?
No, No, I'm still employed, but
Unpaid.
one step
Okay.
from. But I believe that they are spinning, as some friend of mine tells me. They really don't know what to do, because if they do terminate my employment, then it would be wrongful termination because I refuse to violate a federal law.
Yeah, and they
So-
know they're stuck between a rock and a hard place at this point.
That's right.
So
And they can't
they're-
move forward because they just don't know what to do.
so they're really just hoping that they can just keep you hanging in limbo like you are.
Give
and
up.
it's just it's just
they're
not
hoping
gonna
that I
fly.
would just dry up financially and that I would just give up.
Yeah, and that's not gonna happen.
And the trouble with, not that I'm saying anything other than just stating the fact, if you were to go get another job, they're going to have your background check. They're going to ask American, and then the airline's going to say, "What? You're looking for a job? You can't. You'll have to get permission from us."
Yeah.
And they're going to give me the choice: you either quit or you don't work.
Yeah.
And that's the
called
game they're
blacklisting.
playing.
Yeah.
Yep.
Yeah, that's the game they're playing. So that's fine. That's okay. It's
All right. Let's dance.
That's okay. Yeah, that's okay. I want to just clarify one more thing.
Sure. Let's.
regarding this.
I'm going to go ahead and give you the last word here, Captain, because we're coming up on the 2 hours mark. So go ahead.
Yeah, I just want to add that there's that borderline between exercising your right as a pilot, right? You're just flying your own plane, whatever, and then there's that line. Once you step into the commercial realm, okay, now you are contracting with the people. Now we're talking about contract.
Yeah.
Okay, and now you have another constitutional right there, and that is to contract. So you're exercising just a different right. But the right to transit is still there. It did not just disappear.
Right.
Okay. It is just a subset of the right to contract.
Yeah.
And as Crash said, you've got to comply with all the rules and regulations. It does not change. So,
So if
and yeah, I'm sorry, Justice, go.
no, go ahead, finish.
I'm done.
Okay. So then let folks know. I'm sure there's pilots out there that might want to join you, as Crash discussed. I'm sure there's people that might want to reach out to you. How would you like them to find you? Email, or you are now on Twitter. But do you want to share your email for anybody that wants to get a hold of you?
Yeah, my email is the medoverlook@protonmail.com.
Okay. And you're also
And that's the one at Captain Saliba
Full
on
word?
Twitter.
is it
On
the full
Twitter.
word? Okay. Is it full word, Captain, or abbreviation?
No, CAPT, just abbreviation.
Okay.
CAPT.
CAPT
That's correct.
Okay.
Yeah.
Okay. And then the
So-
website again
and
is
I'm
pilotgateway.com.
That's right.
Yep.
That's right.
Good.
It's still under construction. As more information
Not
comes
bad.
in, I put it up.
Yeah.
And there's plenty of reading in the cases.
Yes.
So you can sit there for hours reading those things. And as hopefully I will have some rulings to post as well
yes.
soon. But I'll be updating the information. It's all educational. I'm not giving any legal advice to anybody. But it's good to know where you stand and have no fear, because fear is what they prey on.
Yes, it is.
They're that's how they get you to consent.
Mhm.
Yeah.
Through fear.
And
Like it's like I said at the beginning of the show when I was talking about my case with the property tax suit. If again, guys, how many times have I said that if you don't know your rights, you have no rights? If you don't know what those rights are, you don't have them, and you can't say, "Well, I have rights. I got rights." Okay, well, what are they? Well, I don't know. I just know I have rights. That's not going to fly.
Yeah.
Okay. And it's just like these ridiculous arguments that these attorneys make in these filings. And like these, you guys have to remember, like, even though these judges, like in Captain Saliba's case, have grossly misstated the law and what the constitutional prohibitions against interfering with contract state, you got to remember these guys have been living, swimming, breathing, and dying in the statutory sea. They think that what people write on a piece of paper and then what some other idiot signs into law is gospel truth. And that is unhealthy for a constitutional republic. Unhealthy, which is why if you ask any politician, oh, it's a democracy. It's a democracy. It's like, well, you have no business being in office. If you don't even understand the basic fundamental principles of our government, you have no business being in our government. So I want to thank everybody for joining us. Like I said, this was a couple hours for this episode, but good information, really good information. Thank you, Crash, for being here. I give you a hard time, but I love having you here. She picks up on my sarcasm stuff, which is why I think it worked really well.
That's the only language I speak.
Yes. Thank you to you. And again, I apologize. I will never, ever make that a mistake again. Naval Aviator Crash. Thank you. Captain Cross, again, thank you for being here. So just so everyone knows, I'm going to be out this next week. I am headed out of town on a much-deserved vacation with the family. We will be back in a couple of weeks. We've got some really good shows lined up. Erica has been throwing out some good stuff, some good suggestions. We talked about potentially bringing our kids on and talking about our rights. So that would be a fun show. We've also talked about having some other guests. One of those guests, potentially, this is unconfirmed. We haven't reached out to him, but Brent Johnson is another individual we're hoping to bring on. He's an author on the American Sovereign. I actually have his book around here somewhere, which is a good book. He talks about a lot of good stuff. Justice posted some stuff recently about some videos that he's put out. We're going to see about potentially that. And obviously, as you guys know, as I have updates in my case or any other cases that we're following, we will post information on that.
And we also talked about going through, my sister wants to fight a red light ticket.
Oh, that's right. Yes.
So we talked about doing a workshop and literally walking her through the process live. So that will be fun.
Yeah, that will be fun because there's some good documentation. Alphonse has posted some stuff in his group that was put together by Dave Merland. So I'll give the shout out to Dave up in Washington for that. It's always good information to know and to have. It's like, what happened? How do we put the brakes, so to speak, when these guys are trying to pull us into these administrative courts? Well, we do that with our paperwork and our filing. So, and
then the cameras are just such a violation of privacy.
It is.
Right.
Yep.
So.
Yep. It is. There's so many things. I mean, gosh, we could spend hours about the fact that some of these three-letter agencies violate our rights to privacy. Like every time I go through the airport, I'm sitting here thinking, Fourth Amendment, Fourth Amendment, Fourth Amendment.
Mm-hmm.
How many of them would even be in existence if they were following the bounds of the Constitution?
Right.
Exactly.
I'm a pretty big fan of the Blade Runners over in the UK.
Me too. Love them. If you guys don't know who they are, there's a group in the UK that is cutting down all the spying cameras on the poles.
Good for them.
Yeah.
They're unfortunately having to take those drastic measures because, but if we're not careful, we're headed there next.
Yeah. Just comply our way into slavery, deeper into slavery, I should say.
Yep. Well,
that's the only tool we have really is to not comply.
Right.
And
what have I said before that Benjamin Franklin stated? For those who give up a little bit of freedom for safety deserve neither.
Deserve it, right?
They deserve neither. Yep. So if you give up your freedoms to be safe, you deserve neither. And that's coming straight from Benjamin Franklin, one of our founding fathers. So with that, you guys, again, thank you all for joining us. Those of you who are watching us on our video platforms, please like and share the video. Subscribe to our channels. Those of you on our podcast, please. I don't even know if you like those. I have no clue.
Yeah, you can. You can like them.
Okay, yeah. Like our podcast. That helps to get the word out. We're growing, which is good. And thank you all for joining us. Again, we're here to help. But again, if you don't like the help I'm giving, that's your problem, not mine.
James, he was a troll.
I don't care. It makes me angry.
Well, I know. You have such a good heart. And
Kava would help with that.
That's the last bit of your energy that the troll gets, James.
Yes.
Let it go.
All right, sounds good.
Blow it away.
All right, sounds good. Okay, everybody, thank you. God bless.
Thank you, James. Justice to everyone. Crash.
Thank you.
Bye-bye.
See you next time. We'll see you.
Yeah.
Bye-bye.